Welcome, everybody. This is part of an ongoing series we're doing here at JuristAI, where we're analyzing cases that are very popular and that have a prominent effect on society. But one thing that is different and special today is that we recently launched our civil litigation product. So now we're going to start looking at some of the most popular and interesting civil cases that are in court that are shaping our society today, using AI to analyze them and also using the expertise of our chief legal officer, Mark Underwood. Just to remind you, I'm the CEO of Juris AI, and this is Mark, our CLO, and that is Dakota, our CRO. So,
Welcome, everyone. Happy to be here.
yeah, we're happy to have you, Mark. This is LitigAI, our civil litigation product. Before we jump into it, Mark, do you want to give us a little bit of background about the case that we're going to be taking a look at today?
I will. We're looking at the National Association of Diversity Officers in Higher Education et al. Versus Trump et al. And this is a case that was filed in February when President Trump signed an executive order banning DEI across the board through his office and his ability to draft and craft very interesting executive orders. So, for background and context, it was filed on February 3rd of this year in federal court in the Federal District of Maryland. It was in response to these executive orders that I just alluded to. The orders were perceived as an attempt to fully dismantle DEI, which is the inclusion and diversity rules that were put in place and to some degree have complete constitutional protections, but have been extended to be completely inclusive, and it was adopted very, very generally and generously by many corporations during the Biden administration. And the perception, I think, in the general public would be uh, President Trump is stepping in to erase the entire 4 years of Biden's presidency by getting rid of the DEI rules that were promulgated and promoted during his Democratic presidency. That said, um, this the plaintiffs in this case came together, and they are higher education. They're the American Association of University Professors. It's the mayor and the city council of the city of Baltimore and other organizations that are stakeholders in this, and that's the et al. In the caption that we talked about here. The defendants in this case are President Trump, the Attorney General of the United States, and various other federal officials that are part of his cabinet that are also promulgating and moving the executive order forward in each of the various organizations that they're engaged in. So now, if you don't mind, I'll talk a little bit about the key points of this memorandum. It was filed, there's an opinion from the court, and it's headed to the appellate court. We can talk about that as we move forward. The relief that was sought here was a preliminary injunction, or what we call a temporary restraining order, for this going into effect. So that injunctive relief was what was asked for. The judge in this case, Judge Abelson, granted a nationwide preliminary injunction in this case. One of the challenges that we find in this type of case is preliminary injunctions are meant to be short term.
Mhm.
They don't have lasting effect, and that's why I believe this will be decided completely in the appellate court. That said, the scope of the injunction included the entire United States preventing the enforcement of this executive order. And what that will do is open this up to interpretation at the appellate court level to decide if the parties, first of all, have standing to bring the case. That's always what happens when you have a request for injunctive relief. And then beyond that, it will talk about whether and to what extent the executive order is constitutionally sound. And so my guess would be, based on some of the other preliminary injunctive relief that had been granted on some of the other executive orders, this may end up being shipped back to the district court so that the parties can actually show standing. But we can talk about that a little bit when we get to the summary of the case.
Sure, why don't we pull that up now? So the idea here is basically that Trump is trying to get rid of DEI protections that people are using to hire people in the private sector or in the public sector.
Well, in this case, it's both. It has an effect across the board, right? The first concept would be it would be for federal workers and under the Doge effect, we'll call it, downsizing all government agencies where DEI has been implemented, including the military. But
Interesting.
it does have a greater effect, of course, because the executive order has broad scope across the entire country, even for private companies, because those private companies who felt that they were implementing DEI and it was onerous because of President Biden's presidency would then sweep their DEI completely off the board and there would be no diversity in hiring, et cetera. So there are broad implications here, Ali, to your point.
Interesting. So what are some of the long-term impacts if the Trump administration wins this case? What does that look like? Because right now there's a preliminary injunction, so nothing has actually gone into effect, correct?
No, right now there's the preliminary injunction is in place. The appellate court will decide, as I mentioned, standing very likely, and
Mhm.
then push it back to see if standing works. And as I also alluded to, preliminary injunctive relief is temporary. So right now the executive order stands, but it's being halted, it's being stopped while it's being determined whether or not, first of all, the people have standing to do so, the parties that brought the suit, and then secondarily, whether and to what extent there is merit to their constitutional objections to the executive order.
So
I think it's fair to say there are constitutional exceptions, and I think it perhaps it is has overreach, but I think standing will ultimately end up potentially being the issue. There's plenty of case law around this as well that could be beneficial to the people who brought suit as well.
So when you say standing, can you explain to me and the audience a little bit what does standing mean? What are the consequences of standing in a case?
So you have a group of people, and typically people would understand. For instance, there's a very broad case for people in the military and civilians who were working at Camp Lejeune. Are you guys familiar with that? So there are implications for water and other contaminants that were found on base and near base down in North Carolina. So they brought a suit which was a class action that included everyone there. And so the standing that they got for the class action was you go through some administrative steps to certify that class. In
Mhm.
this case, it's several jurisdictions and national organizations that are bringing this on behalf of their constituency, right? Well, that doesn't typically get you standing automatically. You would have to have people who are part of those organizations who would come to this competent jurisdiction, meaning the federal court in the District of Maryland, right? And it would be Ali, you live in the DC area, so you would bring yours in the federal district that is most acceptable for where you live and where your venue would be most um, uh, accepted by any court of competent jurisdiction. In this case, I think the standing issue may go back to, hey, you don't have any individuals from your organizations that are named here as plaintiffs in this case, and you're not showing how they're standing, meaning how are they being affected?
Yeah.
What are they being denied? How can you prove that? And that's typically how these cases get kicked, is that standing issue. Does that make sense?
So basically, you have to be personally involved to bring a case in court. And if you're not, then your opponent can say, hey, look, this person doesn't have standing, they're not directly individually involved, the court shouldn't even be hearing this case.
Yeah, where's the harm is what they're going to say. How are they going to show harm as an organization?
Yeah.
They represent a bunch of individuals. Show us how those individuals are being, and then kick it back and say the individuals should be the ones that are filing suit. That's an example of something that has already happened with some of the other TROs that were attempted for some of the other executive orders that President Trump immediately enacted when he was inaugurated.
So even if your claims are totally valid, if you don't get standing right, the case can be tossed out.
That's correct.
And here it's this National Association of Diversity Officers in Higher Education, and they're kind of trying to cobble together a coalition with the et al., with all the other people to try to justify standing. So I wonder if Trump has attacked their state. Well, before we get into that, this is the summary of the case. So what we're looking at right here, this is our software. This is LitigAI. When you add the case, it pulls all the case documents. We'll keep everything in a singular isolated AI context window. So every time you interact with the software, it keeps track of everything that's going on. You can see here that it has summarized the entire case. It makes recommendations for what an attorney litigating this case might do next. It pulls a case timeline, and then we also have workflows that we can take a look at in a little bit. I'm curious, has Trump attacked the National Association's standing yet?
I think that'll happen at the appellate court level. I think the since the injunctive relief was granted, that's why the appeal is moving up to the appellate court rather than remaining in the district court. And
Yeah,
as I had mentioned, since it's temporary, injunctive relief by its nature is temporary, then the standing issue, I think, will end up being determined at the appellate level.
interesting. And how long would something like that take?
Well, right now, I believe, if I'm not mistaken, April 8th is when the briefs are due to the appellate court. So give me a second and I will confirm that.
Sure. So it
I'd like to
seems,
share what I think some of the arguments would be on behalf of the people who brought suit.
yeah, of course. That would be very, very interesting.
So the case status is this. The case is currently active and it's moved to the appellate level. It was initially filed, as I mentioned, on February 3rd, 2025 in the U.S. District Court for the District of Maryland. They were granted a preliminary injunctive relief that was nationwide. Under the appeal process, after the district court's decision, the case has been appealed to the Fourth Circuit Court of Appeals. Uh, the appeal was filed on February 27th. They have until opening brief and any appendices are due on April 8th, and the response brief is due on May 8th, so it won't be heard until sometime probably late June. So that gives some time for the injunctive relief to have an effect while these organizations determine whether and to what extent the effect that they're thinking about in terms of how it affects both higher education and public entities like the city and city council of Baltimore, so they can start to share what those effects may be long term, so they can get the executive order overturned completely.
Yeah, yeah. So
It's very
what
likely,
happens?
regardless what the outcome is, guys, is that it's going to go to the Supreme Court. And as we know, with a recent 5-4 decision in another executive order case, I expect litigation to continue because the way the Supreme Court is currently associated with conservatives to liberals, that many of these may be decided by a hair's breadth like the last was. And we can talk about that at another time.
So if this ends up in the Supreme Court is definitely leaning conservative right now. What are the consequences after the preliminary injunction is done with and potentially the Trump administration wins the case? And I think something a lot of people are concerned about is how is it possible that the president has so much unilateral power to undo things that are affecting tens of millions, if not hundreds of millions of people?
The reality is this, when the Constitution outlined the division of powers and having the association between the creators of laws, that would be Congress, the Senate, the House, the executive branch, which has oversight for how we progress internationally primarily, and how the federal government manages budget, and how the United States as a whole shares the taxed individuals in the United States with each of the states, and how that's broken down. And so that has been sort of a butting heads that the judicial branch has always been able to mitigate to a great degree how laws are being utilized and managed, how the executive branch interprets those laws, administration over administration, and how the law will end up ruling the land. There's a little bit of a skew right now with the understanding of the broad powers of the presidency,
Mhm.
how executive orders will be both managed and used as a carrot and a stick. So that said, the judiciary and the houses of Congress are all leaning more so toward a very conservative, uh, possibly religious right bent, which is sort of overarchingly affecting church and state, how the Constitution is meant to work, and the current laws that are in place. So some of the things with regard to the budget that Doge is doing, for instance, those items are not really following the Constitution, and it's really a test of the broad powers of the executive branch and how it may be able to overshadow actual laws that are in place and distribution of funds that are already allocated, et cetera. And those are things that are being talked about very, very widely by legal minds across our country and outside our country, because there's an effect outside the country as well.
Before I ask Dakota if he has any questions or any insights, I wanted to know, since it takes a couple minutes to draft a motion, is there a particular motion type that you're interested in drafting, just so we can get that started? It says here, LitigAI recommends an application for extension of time to file a brief in opposition, a motion for requiring filing of discovery documents, or a motion to expedite consideration.
Those three are very quality, I think. All three are motions that either side may need based on what their preliminary research has shown them and the case law. Based on the case law that I'm seeing, there are a number of court decisions that are applicable here, that any one of those may have an output, and certainly LitigAI, I would think, would have some of those associated with either the motion to require filing for discovery of documents, certainly, or the application for an extension, simply because of the timing. It's relatively short to pull together a very comprehensive brief by either side. And certainly, there's a lot with the legal implications for reinforcing judicial checks on the executive power, which some of these cases, which will push out to the Supreme Court, will, I'm certain, test. Does that make sense, guys?
Yeah.
Yeah.
Let's let's just put a, do you have a legal strategy that you want to just plop in here so we can get this started?
Why don't we just plug in judicial checks on executive power and appeals process to the Supreme Court?
Just remove this.
And while that's loading, Ali, Mark, I do have a question. How does this play out on like a federal level versus state level?
Well, as you both may know, the federal level is the highest and broadest level. States have the ability to, using their state constitutions, to refine and make more precise the implication and application of the laws that are generally managed by our representative democracy at the federal level. So what that means is if DEI is found to be unnecessary and the executive order stands, then those conservative states can use that to, at the state level, either eliminate altogether DEI initiatives at the state for state government, but also to diminish those protections that the state constitutions have that are more beneficial, say, to a protected class currently. So, and it could go the other way with those states that are more liberal, where they could help become a bastion of DEI ongoing. So it's sort of six of one, half dozen of the other, not quite that balanced, forgive me, because you can see the executive branch appears to be trying to push the the lawmakers of our land into an idea that laws really are just like the speed limit. It's a recommendation, not an absolute rule. And that's very troubling to those of us who swore an oath to the Constitution. So,
Yeah, I think one of the things that a lot of people are surprised to find out is that the Constitution vests all executive authority in one person, who's the president. And that's kind of what Trump has been trying to use ever since his last administration to get away with quite a bit. I think right now all of the restraints on his power are just totally gone. How do we reconcile the fact that there's supposed to be checks and balances, but simultaneously, the Constitution does imbibe Trump with this unilateral power to basically make government happen?
well, I think the way the Constitution and the way that our three cornerstones of democracy are meant to work, with the checks and balances that are in place, typically the judiciary would step in, and that's what we're seeing in this particular case. This is following the actual way the Constitution is laid out. If it's not working and there is executive branch overreach, the judiciary is supposed to check that by saying, hey, we have laws that are in place. These are actual laws. We must follow those laws. Now, there's been a subrogation of law all the way down to the state level where judges who are appointed sometimes overreach themselves. And if they have been appointed by the Trump administration during his first tenure, they have somewhat of an obligement. That's not the right word.
Hmm. An
They
obligation,
have
yeah.
they feel like since they're conservative, some of them are extremely conservative, that they're going to follow their belief of what the law says rather than following the letter of the law. And I think that's really why Trump is trying to exercise this authority, is that he has judges in place all the way up to the Supreme Court that may really erode the Constitution as we know it and have known it for more than 200 years. So,
Yeah, it's really problematic. Another thing that maybe we can look at in another episode specifically is, and it ties into this case with Trump's executive orders, was his establishment of Doge and the power that he seems to be giving to people that are technically not a part of the government. And Trump is using his very broad interpretation of executive powers to justify that, just like he is this DEI recension of these two executive orders. So how do we fall on that? It seems like he wants to downsize the government while also increasing his powers. How does the Constitution and the wider judiciary accommodate that or not accommodate that? And what's the reconciliation here?
many of my colleagues and certainly constitutional scholars are wrestling with that very question, Ali. If we continue to erode the Constitution in the way that this appears to be going over the course of the next 4 years, the question becomes how does the United States continue to be an effective governing body for all the states? Will the states decide that their constitutions and the way that they want to manage at a state level end up being confrontational with the way that the presidency and how he is managing our government? Will it come to a head where the judiciary no longer has its place, laws no longer really have the standing or relevance that they have, they really are just guidelines? It becomes more like an oligarchy or more like a dictatorship, and forgive those very strong terms. I'm not trying to suggest anything other than what I fear may happen with the abrogation of the Constitution. And so it's really up in the air, and it really is dependent on quality arguments that really follow the letter of the law. And this is something that I've always advised. You can have a cause to which you are very appended, meaning your heart is completely in it and your conscience believes in this. But you must follow and argue based on what we talked about earlier, standing, based on the law
Mhm.
as it currently stands, and based on past cases. If you can follow that and follow the rules for filing a case, getting temporary relief for the case, and then trying to win the case based on current law and the current judicial climate, then I think that's your best way of winning these sorts of things, and possibly the only way with the
Yeah.
current separation of powers.
Yeah, that's extremely fascinating. So, where do you think this case is going to end up? What is your current prognosis for what you think is going to happen?
Well, I hate to say it, but I think what's going to end up happening is they're going to be challenged on lack of standing. The one thought I think that they may have is by showing the court the increase of access to minorities, especially African American and Hispanic students, and the increase in access to higher education to those particular minorities. I don't know that that will be persuasive enough without those minorities coming in as individuals and bolstering the case from a standing perspective. I think that's where many of these cases are going to fail, is on that standing rule.
And so, what does it look like if this case falls through?
I'm sorry.
What does it look like if this case falls through?
I think they would have to reassess how they refile, because they can certainly refile with actual faces who are going to be damaged by these rules. So those people who are going to be harmed, that have found success with having equal opportunity under the law. So those Hispanics, those African Americans, those young women, all of those people need to come forward and understand that not just the constitutional protections that they've had, but some of the fairness and equality that is perceived to have happened that increased in their availability to the higher education, to access to work in certain fields that may have been closed off to them in the past. That's, I think, the way that this is going to have to move forward. It's how the story is told in association with the law as it currently stands, if that makes sense to you both.
Yeah.
Yeah, and do you think that's something that they're already starting to do outreach for? Like understanding that there is a good chance that it might be upheld?
I really hope so. As you both know, and I talk about all the time, we talk about KPIs, right? What's the data that supports this? And they certainly have the data that supports this, but that's not the human story. That's not what has helped these students. You need to put the faces on the students. You both recall when we talked about Martha Stewart, right? When we were using that with what's now FedCrim, and we had a very nice discussion about how a very high profile person can be ostracized because of their success. I think this is sort of the reverse of that. Show how the faces of DEI have flourished, how they have grown as individuals and what their success stories have been with the help of DEI. I think that's the way that this would work. And understand, DEI or no DEI, the Constitution has protected classes. The implementation of how those protections happen is really what's at stake here, right? So typically, the judiciary has been the demarcation of how that works. Hey, I am in a protected class. I have been discriminated against. That, regardless the DEI implications, should still remain intact. That's our Constitution. And so I think that's the only way to get this ship righted, because I think the ship is sinking for protected classes right now.
Yeah, it's definitely very, very problematic. We're pulling up some of the case citations right now, but let me just go ahead and show you one that I had generated for this case previously. So this was also, I think, a motion to expedite consideration for the Donald Trump case. I don't think you've seen this, Mark,
I
but
haven't.
let's just go to the case citations that it mentions in the end. So it mentions, I'm not familiar with any of these. Moore versus Harper, which is a Supreme Court case. Uh, Bronovich versus Democratic National Committee. Rucho versus Common Cause. Shelby County versus Holder. Citizens United versus the FEC. Bush versus Gore. Americans for Prosperity Foundation versus Bonta, and then Amazon versus Intertribal Council of Arizona, Inc. So I'm not sure
Is
why
this for what motion are we
this
talking about?
is a motion to expedite consideration.
All of those cases are on point for that motion.
Interesting. So I
If
don't,
we
I
were
don't
doing a
know.
motion for standing, for instance, I would have expected that we would have three of the cases that I pull. So I'm guessing that since we have great citations that came out of this for this particular motion, and at first glance, these are all on point. I think if we were looking for a motion to for standing, if it gets shipped down to district court, we would get a similar result for the cases that I had pulled separately using LexisNexis. So this is a very quality output.
Yeah, and what's interesting about the way that we do our citation process is that we don't use AI for this. So we have an actual legal database and we go and do agentic research, and then we provide you with a link to all of these opinions. So you can actually just take a look at them right there. As we give you the citations, you can pull them up. It's loading. I think there's a little bit of a problem with my internet connection. But you can just click the link and it'll take you right to the citation. So we want people to have confidence that the citations they're getting are not hallucinated. That's why we go through every document we produce. Any citation that AI introduces, we remove it. And instead, we give you these validated citations that are real opinions that you can take a look at that are validated so that you can be confident and also so you can do your own research because ultimately the responsibility falls on the lawyer. But what we want to do is enable attorneys that use this tool to have as much confidence as possible. So I'm glad to see that these citations were good. So I don't
That
have
absolutely
any.
makes sense to me, Ali. This is a quality output.
Awesome. And hearing that from you, considering the fact that I look at those cases and it's just mumbo jumbo to me, is is very exciting. I don't have any other questions about this case. I think we'll probably need to continue following it. Mark, do you have any closing thoughts about it?
I think what I'd like to do is do a follow-up on this once we get to whatever the decision is going to be in late May or mid-June, and follow up on this as we progress through looking at cases that are applicable for use in the LitigAI platform.
Yeah, definitely. Yeah, I think we'll need to come back and take a look at this for sure.
Excellent. I've really enjoyed this, guys.
Yeah, this was fun and we really enjoyed having you guys here. Please like and subscribe so that we can keep doing this and make it better. And if you're an attorney or if you are thinking about filing a lawsuit in federal court, please go on litigai.org, go on juristai.org, reach out to us. You can sign up for a demo and we'd love to walk you through the software and see how you can integrate it into your workflow.
Cool. Awesome.
All
Happy
right,
to be here.
guys. Sign off. Thank you. Bye.